And I'm glad to be here. Thank you for introducing me. So all this time, I don't visit translation conferences. I deal with legal translation, and I deal with legal translation for 20 years, and I've been working with big legal companies and other clients. As far as I can see, there are my colleagues here, legal translators, and people who are just interested in this aspect. My language pair is English, Russian, and Russian. English and Russian. So we are going to speak about translation of this language pair of languages. So if you have any questions concerning Ukrainian English translation, don't hesitate to ask. And ask for the mic and ask your questions. So legal texts are translated not only by legal translators, then that might be rather logical. But there are not so many people who specialize in legal translation. That's why the main part of my presentation will be dedicated to those who occasionally got legal translation, because such things happen to any translator, despite the main topics the person specializes in. So where we are going to look for terms if such things happen in our life. First of all, my first recommendation: if you do not specialize in the sphere of law, and you have to translate legal text, what do you think about this? What is the first thing you should do? What would you do if you were in the place of the person who occasionally got legal text to translate? Maybe we will think, should we deal with this text? What is the specification of this thematics of this area? And is it possible to get prepared rather quickly? Okay, any more examples, please? Find examples of similar documents and look how these documents have been translated in the original. Maybe we should use a special dictionary. Yes, we are going to speak about it as well. Legal vocabulary. To my point of view, the first thing you should do, better to refuse, as well as from any text which does not coincide with your sphere of specialization. Of course, if you work in staff as an in-staff translator, you will not be able to refuse as well as you work as an in-house translator. And for freelancer, it also will be not so easy, because they are probably you will lose your client this way, and your client will find a better translator, and so it will be difficult to refuse, or impossible to refuse. The most obvious please ask for glossary. Ask your client for a glossary, and it will be good if your client will be able to provide you with a glossary, because you will not bear so much responsibility, and the glossary may be even good. And probably for your client, for whom you've been translating many technical and medical texts, this case is occasional as well as for you. And probably the client will have no glossary, and you will have to create your own glossary. Then, if you have done it, and we are experienced translators, and we have selected the terms we need for translation, we use different dictionaries, and we want to move further, and we have to find equivalents. First, think about what technical or medical translators will think about its standards, state or union standards. But if you have no sources of terminology, no official sources of terminology, no regulations that which prescribes you which terms to use, there is only practice which has existed for a number of years, and of experience of your colleagues, and words which are in dictionaries. Here we can remember about legal vocabulary, and maybe it was bought a long time ago, and this legal dictionary, legal dictionary on your shelf, which you bought a long time ago, but these dictionaries are rather old because legislation changes all the time. Then, as usual, how about Multitran and other electronic dictionaries? Well, let's try. For example, your favorite client, your company, decided to organize international joint stock company, and they have to translate their regulations, article of associations, and what is English. What are English equivalents for this word? So let us ask Multitran. Let us consult the Multitran dictionary. Okay, if you go to the title legal terms, life does not become easier. In this case, Multitran still gives us the word gives us a more specialized terms.
And two more, and they reflect our reality on one side. And how can we choose? What should we do in order to choose? So we're talking about articles of association now. The discussion is. So, colleagues, what I'm going to tell you about, these are advice from my personal experience, and of course you can see your own methods of work and ways, and I will consult you with great pleasure, of course. And I'm not just the ultimate giver of the advices. So, but for us to find out what term we should pick up from the dictionary, not being professional legal translators, when we are preparing for translation, we should ask for reference. And the client can have a legal department, and should have, and probably he has the translated articles of association, or he may have other documents, and if they're fixed there, you will have to use them. And this more often we can use it from English-Russian translation, and of course they used it and applied with the tax administration office, and of course there were some cases, and the translator is to blame when he didn't match the terminology. So if it's good if you have reference. If you don't have it, we can identify the jurisdiction And so we're talking about, for example, the Russian Federation or Ukrainian articles of association, where our partner is located and what really are closer to him or to her. Okay, let's think that we try to understand the meaning of the terms using the monolingual dictionaries, but article of association, it is just the organs of authorities, registration authorities. For example, England and Wales. You can see the picture. I take it from the British House's house. We understand really the term is article of associations or memorandum of association. And if we have the United States, for example, California, in the United States we have two major legal forms of the companies which are mostly used. They are corporation and limited liability company, and they have the different names of their documents, their legal documents, and here we can see articles of incorporation. Okay, that's good, but in fact articles of incorporation is not the articles of association. Now it is the explanation about the translation into the Russian language. And it is different. And it is more to the founders agreement. And the articles of association in the United States is called bylaws. Are you afraid of that? Are you frightened? No. If we speak about limited liability company in the United States, here, of course, we have articles of organizations, and the same story for the founders agreement, because the articles of association here is called operating agreement. And also other ways of the legal terminology for the articles of association, depending on the context and depending on the jurisdictions and the legal form of the company. So, and for those who didn't decide to use number one and to decline the order, to refuse the order, the job, you will not be able to look all these terms. Okay, we use internet and we identified jurisdiction and law. We understood the meaning of the terminology using the monolingual sources. We don't have the exhaustive list. Of course, you can add a couple of slides here as a practicing legal translators. If we translate into English, you can see online websites of the registration bodies of different authorities of different jurisdictions, the websites of the courts of different jurisdictions, also legal companies of English-speaking legal companies. So we can also use the Russian websites, but with certain restrictions. When we use translation into Russian, Garant system, why I use them the translation into Russian, because they're really very good as the collection of laws. They're correct, right, but they include the translations of English laws in English, and they can be taken from different sources, and usually the reference is made and the link is made. But you need to check it and double check it, because you can see the official approved, recognized option of the agreements, for example, UNCITRAL, or you can face with something which is taken from nowhere. And you should be very, very careful using this. And if this is a trial documents, you should check the websites of courts and e-justice system. But it is not. They of course published anywhere, and now the system e-justice appeared recently, and the idea is you will be able to find everything so far. But so far is not. It is not. It doesn't work. So I can recommend you to use the corporate. Of course, for 30 years of our building capitalism, our colleagues have worked. They aggregate the knowledge base, but it can be on the side of one single company, and they don't want to share it with anyone. But there are, of course, some corporates who can publish their glossaries, their bases, and they're voluntarily published in the internet. You can come across to Morgan Stanley company glossary, 10K company. It's very huge and it's not convenient to use, not user-friendly, frankly speaking, because it contains almost everything, but they have a legal parts in it, and it's not very bad, really. Next, the monolingual dictionaries. The most popular is Black's Law Dictionary. And of course, you can use general dictionaries, general monolingual Merriam-Webster's or Oxford, and all the terminology which is included there. They are explained in a very good language. Articles in the legal magazines and journals, articles in the translation magazines. For those who is a newcomer to the market will be amused, then forums of Multitran and Lingua or Old Kudos from 2003-2007, really. They are very experienced translators there, and they published their posts there. They discussed it, and it was discussed on the forums, and you can read it and understand. And you can understand the algorithm of the search, how to do it properly, and this is more to the legal translators. I'm not going to focus your attention on that. You'd better do this job and forget about that. One more source, and it's in the end, and it is highlighted in red, and websites of international organizations. This is a very valuable source, and it was higher above before, but why I wrote it down, I will tell you a bit later. And that's the source. It's endless, and we can use 10 slides. Then UN Tom, the Commission of International Law. These are places where you can find glossaries created and published by these organizations and recommended by these organizations. You can have documents translated into the official languages of the United Nations member states and Russian as well. The International Chamber of Commerce, the Federal Commission of UN Commission, and there are websites of the profile organization and you should put they even have the translation memories database and terminological database, and you may use it, and they are very reliable reference. And of course, you cannot trust completely to anybody, especially if you use your terminology based and they are contradict with your own experience, because the organization is very huge, but basically they have quite quality. So and many other international organizations which publish information on their websites.
Next, my colleague Natalia Pavluk kindly agreed to give me access to her group, and I copied her recommendation. As for terminological sources in Ukrainian language, I know that I can rely upon Natalia because she also teaches legal terminology, and I think many of you know this person. So 10 seconds for a photo. I would like to add that presentations will be available online after the conference, and also interactive references. So you don't have to, you can all just download these references. So when we have done the first step, let us come to the second step. We must choose the proper term from a bilingual dictionary. Nothing new. The same lingua and multitran dictionary. For those who needs to do it rather fast, I would advise lingua, because in lingua the scope of choice is narrowed, and multitran is a dictionary which is filled up by the users, and there are different users, and if you are not experienced legal translator, you can see it that the user was not experienced. And from old time we know the names who really made a deep research before filling in multitran database, but the list is rather long. I trust the terms added by Alexander Matitin, Evgeny Dalmachenko, Leonid Shipko, but I believe there are also other people, and but still be critical as for terms added by users. But in my opinion, you may trust the people I have mentioned. When once you have chosen the term, you have to check whether it really exists in the context we need, if we are not mistaken. And it is an obvious usual procedure everyone does working with our sphere. Then we have to check it up in these sources. Once we have chosen the term, once we have checked it up, we fixed it, we write it into our own glossary and client's glossary. Before we start working, we have to discuss another topic. The letters, should we write with capital letter or lowercase letter? Before we faced with Anglo-Saxon law and English language sources, in legal documentation, usually none of the terms were written from capital letters. But once again, even this topic is widely discussed among lawyers and translators. What I would prefer, I write only the first word from capital letter, and not all terms I write from capital letter. It's too much to my mind. Usually I capitalize the parties in agreement or in the trial. Or, for example, if a person buys or sells shares, but still, the situation may be different in English-speaking term. If we speak about special status of the term, you have to agree upon the special status of the term or consult whether the term has the special status. And for example, if you translate a general agreement and nothing special, there's no special information about special term, but within a period of time, you will translate additional agreement to this term, and you will face with the fact that all terms written with a capital letter should be written with capital letter, and you translated it some time ago and wrote it with lowercase letter. But still, it is your decision as the translator, or as for legal translators. Here I cannot give any special recommendation, because I believe if we discussed it together, we would face the fact that we all use the same methods. We are all using the same methods. But I think it is important to pay your attention to the fact that if you deal with legal translation and it is your main sphere, pay attention to your client. Who is your client? Your client may be a professional bilingual lawyer, and maybe it can also deal with business of translation, but everything is interconnected, intertwisted. So it is a bilingual professional lawyer. It's a good source of terminology, because this person may know the terminology, but probably he will not share his knowledge with you because he doesn't want to deal with it. Maybe he will provide you with glossary, and then he will correct what you write, because the last person who will read the document in a legal company will be a lawyer, not an editor or a copywriter. It will be an editor, not a corrector. Also, if your client is a professional, a lawyer, but he or she doesn't know the language very well, so you will have to deal with this person. You will have to discuss the terms, and probably he will help you. And usually we face with such clients, usually legal companies refuse using translator services due to providers due to those companies who provide low quality services. And while I was preparing this presentation and I tried to analyze the market, people say we will place bilingual people because translators translate badly, and unfortunately this is practiced by the whole companies, large companies. Probably we will face with such clients. Your client does not understand anything in your job, and he doesn't have to. He has to deal with his own problems and not with yours. And you will have to work yourself, you will have to compile glossary yourself, and Next situation, your client is not a lawyer and he expects everything to be clear by itself. And it's your job to make everything clear for your client. And this is the recommendation to those who occasionally are faced with legal translation. If you do not understand it yourself, if the translation is not clear for you, it will not be clear for your client or for anyone. So you have to provide optimal quality, and we need it and the client needs it. And the second aspect, we have to improve our level. In legal translation, we have the situation when, for example, if we compare to technical translations, in technical translations a large number of people work, and people have glossaries, and we don't have it in legal translation, and we have to change the situation. We have to change the situation. And when you were if you were trying to find the equivalent quickly, I would recommend you come back, analyze again, check up through the database and through websites. And there is also a very good source, which wasn't mentioned by me. It's a lawyer. If you have a lawyer among your friends, for example, share and discuss, and also share the result of your research with your colleagues, and thus you fill in the database. And also how to work with terminology. This is a slide taken from the textbooks, written in details, because we are interested in detailed research during the process. You have to do the same things we have already mentioned. And the last point, if English and Russian terms do not coincide, and such things also happen because sometimes we deal with unique documentation when legislation constantly changes, and sometimes terms are not correct, they do not match completely, and you have the right to improve these terms if you don't have any official sources. So you have the right to improve the terms and create your term. For example, if you have a number of terms and some of this and these terms do not match, and if you have opportunity to consult, you may also offer your term.
What I have here, here's the slide was offered by my colleague Evgeny Tamarchenko. Of course, I advised with my colleagues preparing this presentation, and it seems to me that as many of us have such so of course I'm just beating around the bushes, and I have colleagues who have the right idea what to do, but this is experience of all the colleagues, of my colleagues, and I can tell you a story. I've heard it big, except the colleagues who teach. Natalia Pavlyuk, Evgeny Tamarchenko. He did a lot of research. So this is Evgeny. He is very qualified specialist. He pointed my attention to, and this is his slide. He gave me this slide, and what does he mean here? There is linguistic system and the legal system, and they cannot match. And this is a characteristic for the Ukrainian. In translators, you can have the agreement under the Ukrainian law, and you have to translate it into the Russian, and you need to understand both systems, and of course we can translate into the law of the Netherlands, for example, or UK, and we will be able to find the sources, and we should be ready. And if we manage to find anything, and should record that, memorize, understand, record, and memorize. And I can see a lot of holy wars about that. That legal translators don't have to use the cats because the clients do not require it, but opposite. On the contrary, you should use cats because cat tools can help you, and you should. I would use it and prepare glossaries, and this is my dream. I should learn how to edit translation memory, and I'll do it by all means, Svetlana. Don't worry. Then the procedure, how we work with terminology, a little bit of linguistics. If we cannot find the relevant term, we should make our own. For example, with the right. Now, the translation of the word right into the Russian language, Constitution. You can see this slide. I'm not going to read it. And of course, we more often have the false friends of interpreter, the partial match when we have terminology and they look like as the equivalents, but their meanings are different. And these are, for example, limited liability company. This is the internal dispute. How should we interpret it or translate it? We should use the closest equivalent, or vice versa. We should underline, highlight it as a other realia, other law, and we almost often discuss that, and we have no the universal solution. For example, closed joint stock companies, the ways of translating it into Russian. But some of the legal translators recommend to use the Russian transcription and zero equivalence. There are no terms in the Russian language because there are no phenomenon such as equitable relief. How can we translate it if we don't have the estopel as the notion in the Russian legal system? What should we think of when we make our term, or we choose it out of the suggested, what sources suggest us? And now some examples. Now they're going. For 4 times I rewrote this presentation, and I accumulated the examples, and I didn't manage to do the smooth transition. But I think that, so colleagues, if you have any legal comments on that legal translations, please, you are welcome. So now the discussion about franchising agreement and the ways of interpreting it into the Russian language. So legal translators, please be silent for a while. First of all, let us ask. Now they discuss the ways of translating it into the Russian language. Now you can see how it is translated as franchising agreement, how it is translated into Russian.
счетов столкновения с англосаксонским правом. Но, к сожалению, наверное, этот не франшиза только, конечно, а франчайзинг, он, к сожалению, наверное, будет побеждать. Потому что так многие уже говорят, ну, юристы
And probably just the pronunciation on the Russian way of this terminology will finally replace the correct translation. And the literary translation is the agreement of commercial concession. So, franchising agreement into Russian literal translation means agreement of commercial concession. Then discussion how to translate franchisor or franchisee into the Russian language. When it is not compulsory for us to use the Russian legal system when we translate, for example, documents which are not under the Russian Federation law. Of course, it is recommended to do this for you to understand what you deal with, but in the law there is a user. But we can use also the word again. These are examples of arbitrage court. When this term came into Russia, it was for the state bodies, for state trials, courts. And our courts in Russia, these are state-owned arbitration court. In the Anglo-Saxon law, and it is called other way, and it was a confusement, very great and very complex, and they started doing with that, but you can see the options of the translation into English, and it can be translated like arbitrage or commercial court. If you use arbitration court, it will be other type of the Russian Federation court. So, and the half of the lawyers considered this as a correct option. For the past 5 years, the common sense started taking over, and the tendency appeared. There was a tendency to know the Russian commercial courts or arbitrage as the commercial courts. And yes, they about the economy facilities disputes. But arbitration court still exists, and for today in Russia we have 4 laws which regulate arbitrage. And don't think about, please don't think about the unification of the terminology. In the past, recently adopted laws, they use other words synonym in brackets, and it does not ease our task when we decide what we should choose. But there was the translation of the procedure of the London Commercial Court. It's not a state body authority in Britain, and it turned to be London Commercial have become, and you can see it had the other abbreviation in the Russian language. And to identify the nominate the processes what we have during these commercial hearings. It is called arbitrage in the Russian Federation. And unification of the terminology here. I hope that we won't survive till that time. And every time it is case by case solution. Next, you will see only the examples of the translation from Russian into English.
And I think we may finish on this point. Our time is up. I hope you enjoyed. Thank you for helping me in the process of preparation of this presentation. If you have time for questions, thank you for your attention. Thank you for your for the work, for your effort, because we can see how many useful sources you raised, and thank you for this. You provided us with really useful information and useful sources. Let me ask you the question. I belong to the category of translators, but who decide to refuse and not to deal with legal translation. We all know that translator's mistake has a certain price. For example, if a literary translator made a mistake, it can lead that the whole book has to be will have to be republished. In marketing, the product will not be sold. In healthcare sphere, that can lead to worse consequences. And how about legal translations? What is the price of the mistake made in legal translation? Well, the price. Mistakes made by legal translation will not have a large consequence, because many consequences, because these documents will be read by a lawyer, and the cases when, for example, a missed comma in the text had a cost of 20,000. Well, these cases are rather rare, and we try to avoid making mistakes. We have to be professionals, and still our responsibility is a little bit lower, but we have to be fair to ourselves, and we have to be professionals. And we all cooperate with lawyers. Still, if we do not have such large responsibilities, still we have to work professionally. Thank you very much for your report, and I have two questions. As for legal translators from Ukraine, why do you highlight and red light this source, and why do you ban it? Some sources, I don't want to mention them directly. I just didn't want to use it, because these sources use machine translation. You when you address to these sources, you think that it is made as in Multitran, that it is selected and compiled by people. You click and you can see machine translation. Well, it is their own right, but some sources really use it, and these sources were recommended as reliable ones some time before. Now, I would say be careful with these sources, check them before using them. And secondly, we faced with it after the year 2010, when Civil Procedural Code was changed, and one of the articles was reformulated as for the in-court translator, as for the court translator, and usually, if you know the terminology well enough, could translate, and now only a person who has a diploma or certificate of a translator can translate in courts. You see, a notary, we have a law about notariate, but nothing is written about translator, and a notary can a notary can approve anybody's signature. As for law enforcement bodies, can just address to the person, and we had a very bad precedent. It was the first precedent when for the content of translation an interpreter, a translator was taken to court because there was the story runs as follows. There was a woman who signed and who signed documents. An investigator came to her rather late at night, and she couldn't refuse, and she made a translation with the help of Google, and nobody would pay attention to that, but the translation was made from Georgian language, and the lawyer who dealt with this case knew this language, and the translator suffered because it was said that she had an intention, and she couldn't justify herself. She couldn't prove anything, and she was told that it is your professional duty and you didn't have to agree, and she was just given a probational term, but still it was a very unpleasant case, and it is a real story. And I think we may discuss this topic for a very long time, but let us communicate after the presentation, and we are preparing for the next report. Please don't go away.